Thank you all for joining us today for our InfoTrust Tag Inspector webinar, specifically around the California Privacy Rights Act. Today we'll be discussing how marketers and advertisers need to prepare, and some of the things that they need to be aware of with the new act, new regulations, everything that's been updated there. Before we get fully underway, a few kind of just items of housekeeping. First, this is one in a long series of educational content, webinars, articles, everything that we put out on both the InfoTrust as well as the Tag Inspector websites. For anyone joining, if you have not joined these previously, and by these meaning what you see on the screen there, the data analytics engineering office hours, we do have another session for this next week. It's a few of our analytics engineers on the InfoTrust side of the house basically join. You can dial in, ask any questions that you have around engineering and data analytics. Super helpful. Would love to have you join us for that next week as well. A little bit about myself. My name is Lucas. I will be presenting here today. I work with a number of our clients across the globe, really on all things that have to do with privacy and governance as it relates to data collection, data processing, and activation of that information. Who we are, Tag Inspector is a product of InfoTrust. Tag Inspector is a tag auditing, data collection, data governance auditing platform. As mentioned, it's a product of InfoTrust. On InfoTrust side, we do consulting around all things data collection, data activation, advanced analytics. As mentioned, this is one of a series of educational events that we put on, both in person as well as digitally. So hopefully this is helpful. Quick call out, while we will be discussing the CPRA today, and we'll be going into some of the requirements and some of the different things that are outlined within it. This is not meant to be legal counsel. Ultimately, sharing a point of view, hoping this can be educational, really wanting to try to bridge that gap between practitioners as well as the compliance folks, so that we can understand, get on the same page, and start actually taking strategies to enhance the usage of data, but enhance that in a compliant manner. Ultimately, any decisions that you're making around these different topics needs to be approved and reviewed by your own legal counsel before kind of moving forward. Cool. With that, we can go ahead and jump in. Oh, one last point. I'd like for these to be more conversational in nature. So you'll see within that Zoom webinar pane, there is a Q&A area. I have the Q&A as well as the chat open. If you have any questions as we're actually going through the content, please feel free, drop in any questions, any comments, anything you're curious about into those panels. We could dig in a little bit deeper on those topics. Want this to be as helpful as possible for you all that are joining here today. As always, the question, yes, this is being recorded. Yes, it will be sent out, as well as the deck itself. So with all of that out of the way, what we'll actually be covering here today is in terms of the content. So our agenda. First, real quick, what is the CPRA? Quick overview, just to get everyone kind of on the same page. We'll go through some of the basics of the CCPA, which the CPRA updates the CCPA. We'll go through some of the basics and the core definitions and some of the things that as marketers, advertisers, we really need to understand in order to start applying these different principles. We'll then walk through the 5 main key operational impacts that the CPRA introduces and really enhances in the CCPA. These are the things that we're going to need to be preparing for, because obviously CCPA has been in place for about a year now, enforceable for about a year now. So some of these foundational aspects are going to be there. What are the things that need to be updated as a result of the CPRA? Those are the things that we'll be going through. We'll then walk through some recommendations and strategies for actions to take to be able to really optimize your usage of first-party data in that compliance manner. And then finally, at the end, we will wrap it up with summary, and we'll get to any questions that have not been answered to that point. So with that, let's hop into it. So first, what is the CPRA? So when we talk about the CPRA, it's not just another acronym. It stands for the California Privacy Rights Act. What this is it was an act that was passed back last year, November of 2020, and it updates and expands upon the California Consumer Privacy Act. So it clarifies a number of things, as well as adds in some additional rights and establishes a new regulatory body that is responsible for enforcing and upholding the privacy rights of consumers. Now, there are a number of provisions within the CPRA. Some of those have actually already become operative. Things like the establishment of the council, which we'll talk about here shortly. But most of these provisions, as it relates to kind of changes and more tactical operational things, they are going to need to be in place. Most of those become operative in January 1st, 2023. So there is a little bit of a runway. It's important to understand what those impacts are today and then start developing a strategy so that here over the next year or so, we can get these different modifications in place. Also a call out in here, there are a number of regulations that are outlined within the CPRA that are still to be defined. We'll talk about some of the core ones and some of the implications there, but there are new rules and there are new guidelines that will be coming out here over the next year, up until July of 2022. So it's important to keep that in mind and stay kind of flexible and stay on top of those changes and be able to implement the new requirements as those are introduced. So that's what the CPRA is. As mentioned, it updates and expands upon the CCPA. So that means it's really important to understand the basics of the California Consumer Privacy Act first. Now, if for anyone who has been joining our webinars and our events here for the past several years, might remember back to 2018, 2019 when the CCPA was first passed. We had a lot of content around the CCPA specifically. And when we talked about that, we were talking about really 4 core rights that were outlined within that act. And with the CPRA, it actually expands those and provides some additional rights to Californians and to consumers. So now when we talk about the rights that are afforded to California consumers, we're talking about 6 things. Number 1, consumers' right to know what personal information is being collected about them. So requirements around transparency, requirements around notice. We're not going to get into the granular specifics of this needs to be available at the point of collection. This needs to be available within the privacy notice here today. But there are a number of resources on the Tag Inspector websites as well as the InfoTrust website that do outline a lot of those requirements. The second right here is the consumer's right to know whether their personal information is sold or shared and to whom. So this plays into that transparency, but you need to be aware of where data is flowing, and you need to be able to disclose that to users at the point in which that collection is happening. Consumers also have the right to opt out of the sale. And really importantly here, because this is something that was added in as a result of the CPRA, the sale or sharing of personal information. We'll talk about some of the specifics as it relates to sharing, specifically as it relates to marketing and advertising. But that's a big area there from an operational impact. Users now have that right to opt out of the sharing of their personal information. Number 4, consumers have a right to access their personal information. So these would be the data subject access requests that your compliance teams know and love so much. CPRA actually expands upon this a little bit. There are a few more disclosures that need to be included within those access responses. And then you also, some more information in there, some more requirements as it relates to access. You also now have within CPRA some more provisions around data portability. And so kind of cleanliness of data, the ability to use that and transfer that to other parties. Number 5, consumers' right of no retaliation following the opt-out or exercise of other rights. So regardless of if a user is opting out of that sale or that sharing or exercising their rights for access, we can't treat them any differently. We can't retaliate against those consumers. And then finally, number 6, consumers' right to limit the use and disclosure of sensitive personal information. This is something where, again, introduced in the CPRA, this special category of sensitive personal information. And consumers have a right to limit how you are using and how you're processing data points that fall within that categorization. So we'll talk about that a little bit more here as we move forward. A quick question here in terms of just comparing CCPA and then GDPR and asking if they're fully aligned or if we're seeing one of the two being more restrictive or covering broader areas, comparing kind of one to the other. I'll reference some kind of aspects of GDPR here as we go through this. They're different in a lot of ways. In terms of, are they fully aligned? No. There is a lot of different nuance, specifically around things like consent and opt-in versus opt-out between GDPR and CCPA. In that regard, in terms of the controls or the limitations that users have for how information can be processed, GDPR is more restrictive in that sense. But with the updates of the CPRA, especially around like transparency, some of the principles that are introduced that we'll talk about for data minimization and retention, and kind of lawful uses of information, they are getting closer. So I would say GDPR is kind of more wide-ranging in many respects as well as more restrictive. But with the CPRA, it makes the CCPA become a little bit closer to that for the users and the individual's rights. As far as specifically on the CCPA here and who it applies to. So a really important point, and this is also a differentiation between GDPR and then the CCPA, is that CCPA applies specifically to businesses with consumers in the state of California that meet any one of the following criteria. So it is restricted in terms of who it applies to. It doesn't apply to everyone, whereas the European legislation, GDPR, that does apply to all European residents. As far as these categories for the CCPA, only one of these categories needs to be met to be within scope. But if the business has annual gross revenues in excess of $25 million, if they annually buy, receive, sell, share personal information of 50,000 or more consumers, households, or devices, or if the business derives 50% or more of annual revenues from selling consumers' personal information, if any of these criteria are met, they're falling within the scope of CCPA. You need to be following these different restrictions and these requirements and rules as laid out within the law. A few important definitions here, just to really establish and make sure that you're aware of, because whatever, especially as a marketer, as an advertiser, if you're talking with compliance folks, you need to be speaking the same language. These are kind of the core vocabulary items that you're going to want to understand and make sure you're on the same page with when you're starting to have those discussions. First, the definition of personal information. Now, personal information, the definition of this is broader in the CCPA than it is in GDPR GDPR specifically. It's broader in the sense that personal information here, as defined, it's any information that identifies, relates to, describes, is capable of being associated with, or could reasonably link directly or indirectly with a particular consumer or household. It's a rather broad definition, and it does catch things even like pseudonymous identifiers, so user IDs. It does not have to explicitly be something like an email, for example. And in fact, things like an email, when combined with account information or a password, actually fall now within the definition of sensitive personal information. So there's even more protections on those data points. But personal information, broad definition, anything that can be associated with a particular user. This includes, this is explicitly outlined within the text, it includes internet activity, including browsing and search history, as well as web tracking data. So any kind of information, again, that we're using for marketing, using for advertising, observing the behavior of users across our digital properties, one, to just understand behavior and optimize, and potentially personalized experiences, as well as to use for audience creation and targeting purposes. Those data points, specifically those which are tying together those interactions, so like a client ID or a user ID, those are all falling under this definition of personal information. Now, it is an important call out here that personal information does not include consumer information that is de-identified or aggregate consumer information. We'll talk a little bit more about when we get to some of these strategies. Platforms are starting to introduce the ability to collect observed behavioral information of users without any kind of an identifier that you can associate with them. So more purely anonymous data sets to still allow advertisers to, say, understand campaign performance and to do some, have at least some level of attribution for campaigns and be able to optimize campaigns as well as to optimize user experience on the website. You can do all of that without having any user information. That falls outside the scope of the personal information. So it is a compliant way to address some of those use cases. And finally here, the consumer, any natural person who is a resident of California, however identified, including by any unique identifier. The next three areas on here, I'm not just going to bore you with definitions for this whole time, but these are, again, important. For collecting, again, it's receiving information from the consumer, either actively or passively, or by observing the consumer's behavior. So again, any data collection that's happening for marketing advertising, that's including things like analytics, just information collected by our tags. The definition for selling, renting, releasing, disclosing, a consumer's personal information by the business to another business for monetary or other valuable consideration. It's important to be aware of what selling is because of that ability to opt out. It was more important when the opt-out provisions were specifically related to selling. With CPRA, it expands that for the user to be able to opt out of also the sharing of their personal information. And sharing, really importantly here, is making available, transferring consumers' personal information for cross-context behavioral advertising, whether or not for monetary or other valuable considerations, including transactions in which no money is being exchanged. So when we think about sharing of information, when we think about combining, integrating data sets, or kind of pulling in third-party data sets in order to enrich user profiles for audience creation, those types of behaviors fall under the sharing definition. So when a user is opting out, they're effectively opting out of an organization's ability to really leverage any of their personal information or leverage a personal identifier in any way for purposes of targeting. Any kind of a targeting that is based upon behavior, so even like creation or inclusion in data sets to create lookalike audiences or to remarket to those individuals, them opting out under these new provisions would effectively be that user opting out of that activity as well. That's a big impact here of these changes for CPRA. Last thing to mention here, penalties. Administrative fines up to $2,500 per violation if those violations are not intentional, and then up to $7,500 per violation if intentional. These can add up. Per violation could be, per individual user that is being included illegally or non-compliantly within those different data sets. So if you're talking about a really large data set, a really large user kind of database, you're talking about some very, very large administrative fines, not to mention just the general publicity and kind of damage to your brand in general for violating users' privacy, being that privacy is such a huge kind of talking point at this stage in a big area where consumers are beginning to focus on. And it's a strong value proposition if your consumers are able to trust you. So those are the basics, what CPRA is, some of the foundational aspects of the CCPA. Now I want to talk about some of the key operational impacts that are introduced as a result of the passage of CPRA. So we can really talk about what is changing. And then following that, we can move on to some specific actions and strategies that you can begin employing at your business. So operational impacts, we'll dig into each one of these in a little bit more detail, but the 5 big ones, again, this isn't fully comprehensive for compliance purposes. There's a lot of operational impacts, but the 5 biggest ones that are going to impact marketing, advertising, and how we're dealing with data in those contexts. Number 1, the creation of the California Privacy Protection Agency. Number 2, expanded consumer rights. We'll talk about those, what those are specifically. Number 3, some new provisions for data retention, as well as data minimization. Number 4, audits and risk assessments, and what's going to be required there. And then number 5, some different protections around automated decision-making and profiling. So to start, for the creation of the California Privacy Protection Agency, over the past few years, in talking with a number of organizations across the globe, the thing that's always been interesting to me is compliance and legal obviously cares about the regulations and making sure that everything is compliant, everything is up to snuff. But when you start talking to data people and people more in kind of the business strategy side, oftentimes there's a little bit of a hesitancy to jump all in and make sure everything is fully compliant. And there's really a way of what are the risks to the organization. And so when a regulation gets introduced, if there are no teeth to that regulation, if there aren't, if the risk side of the equation isn't really high, oftentimes there's just slow for organizations to adopt the different types of protections that are really necessary. One of the things that the CPRA introduces is this new agency. And it's the first state agency in the United States dedicated to privacy. So it's a 5-member board that are able to, they have hiring powers, they'll be really hiring people, auditing directors, and all of that within that agency, specifically tasked with enforcement of this privacy law in California. So it is established, it is there. It also has funding. So written into the CPRA during the first fiscal year, 2020 to 2021, $5 million in funding. During each year following, $10 million in funding coming from the California General Fund. Administrative fines also here, as levied under the CCPA, feed back into that operating budget of the CCPA, the California Privacy Protection Agency, or the agency. So many acronyms. But what that really means is as they gain steam, start identifying privacy issues, it's theoretically possible that that agency continues to grow. So the more protections and more enforcement actions they're able to bring, then the more the privacy, the more funding and the more money that they have to then pursue other actions and other organizations. So there are teeth to these different laws and these regulations. And hopefully that inspires everyone to really prioritize and make sure that everything, those protections are in place, and consumers' rights are being upheld and being followed. As mentioned, the agency is responsible for enforcing as well as setting out new rules and regulations. So within the CPRA, there is a requirement written in for regulations covering 22 different areas. And the agency here has that rulemaking authority to define what those requirements, what those regulations are. So I mentioned at the start that a lot of the different provisions in the CPRA become operational at the beginning of 2023. These also would become operational at that time. And the agency has until July of next year, July of 2022, to define those different regulations. So there are more rules coming. The kind of subjects, if you will, that those rules need to pertain to are outlined, but the specifics for what we're going to need to follow are not yet. And a couple of those we'll actually be covering here as we talk about some of the other operational impacts. So be aware, super important to be aware that things are not fully set in stone as of right now. Again, be flexible, have that ability to be agile in your different approaches. The second big operational impact here is around expanded consumer rights. So more consumer rights are conferred upon California consumers with the CPRA. The first one, mentioned it before, is that extension of the right of consumers to opt out of sharing as well as selling of personal information. Now, we looked at that definition before. It's super important here, again, just to drive this home. This extends to that cross-context behavioral advertising and the sharing of any kind of personal identifier or personal information for that particular purpose. How that process works from a technical standpoint, create an audience, and sure, that's what you see within the interface. Under the hood, essentially what an audience is just a list of identifiers that you're then pushing or sharing with a different platform or a partner that you're working with, that is then being used for advanced logic of profiling to either determine a lookalike audience to target similar users or to target that particular audience for remarketing purposes. So any kind of personalized one-to-one behavioral-based targeting is going to fall under, again, this definition. So super important for those opt-out mechanisms and for users opting out that you're identifying how exactly or who is opting out and making sure that there are technical mechanisms in place to be able to remove those users from those audience lists and from those data sets that are being used even for determining those lookalike audiences and targeting other similar users. If we're not, that would be kind of fall under that violation here, or would likely fall under that violation here under the CPRA. So super, super important there. Number two is that users are granted an additional right to data correction. Now, this doesn't have as many operational impacts really as it relates to the targeting aspect, but operationally from how we are defining the overall data collection architecture and managing our data is significantly impacted here. It used to be a best practice to have complete and accurate data. Now that accurate data piece is a legal requirement. Especially, I know a number of organizations as of now are still folding in purchased or supplemental third-party data to their user data sets to enrich their consumer understanding. Once you have that information that's going to apply to those data points as well, you're going to want to make sure that any information that you're pulling in for those purposes has a strong provenance. It's coming from a location where it is accurate and where it is was lawfully obtained from that particular user. No one's opting out, and then that it is correct. So operationally, this can have a big impact. The second, or the third, I guess, big operational impact for the CPRA is around the topics of data retention and data minimization. Now, the question before asked earlier around GDPR differences and similarities with CCPA. This is one of the things that GDPR calls out, is around data being only used for a specific lawful intended purpose, not stored or kept or processed for any period longer than what is necessary. CCPA did not have provisions really specifically for that. CPRA, though, adds this in the general responsibilities that are outlined at the beginning. Specifically from the text here, a business's collection, use, retention, and sharing of a consumer's personal information shall be reasonably necessary and proportionate to achieve the purposes for which the personal information was collected or processed, or for another disclosed purpose that is compatible with the context in which the personal information was collected, and not further processed in a manner that is incompatible with those purposes. What this means is we have to be more strategic in what information is being collected, how long it is being stored, and then how long it is being processed and what is being processed for. So operationally, users now have the right to know the length of time the business intends to retain each category of personal information. And if you can't provide the specific length of time, you need to be able to provide the criteria used to determine such a period. This needs to be disclosed, both for any of those disclosure access requests, but also there are provisions for disclosing this information at that time of collection or within your privacy notice that's available to the user. So for any data that's being collected, any personal information that's being collected, you need to know how long is that going to be retained and be able to broadcast that and provide that information to the user, which means you have to have a strategy. The strategy has to be in place, and then you also need to have those operational technical protections to be able to delete data following those defined time periods. Also here, data can only be retained and used in a manner compatible with the disclosed purposes for processing. This gets to that point of data minimization. It's always been a best practice, limit the data and the information that's being collected to that which is necessary for the purpose. Too many organizations, though, one, won't have a purpose for data that's being collected or for user information. It's kind of that whole idea that a lot of organizations fell into where let's collect as much as we can and then we'll figure out what to do with it. Again, here, GDPR already for European users stipulated that that's not legal. This introduces that same concept here in the United States. So you need to be intentful with the information that's being collected and have a specific use case and have a specific purpose for how it's going to be used. Number 4 here for those operational impacts, audits and risk assessments. Now, there aren't specifics outlined yet. Those specific requirements are still to be determined by those regulations from the agency that we talked about before. But we can get some clues. There are some information on annual cybersecurity audits and then also regular risk assessments that will need to be run by organizations that has been deemed necessary. And then necessity there is going to be for organizations depending upon the scale of processing of personal information that is happening, as well as the risks associated with that processing. So again, still some specifics that are going to need to be really outlined and defined here by the agency moving forward. But when we think about this, and again, getting a little bit closer to GDPR, we can take some hints from the balance and necessity tests that are outlined in GDPR. So number 1, necessity tests, doing some assessments for is the collection and the processing of personal information really necessary to achieve the specific business purpose for which that collection and that processing is happening. So being able to really weigh that and embedding those types of considerations into your actual data strategy process, as well as your data operations process, to be able to answer that question. And then also doing some testing and risk assessment, balancing the risks associated with the processing and the collection of that particular data point that would fall under personal information, balancing that with the benefit that is going to be realized by the business, by the organization, by the consumer themselves. So assessing how much of a risk there is there, assessing what the benefit is, and then being able to have a defensible position that the benefit outweighs that risk. So more to come for this, certainly, but something to really be thinking about as we're thinking about data strategy. And then finally, the last operational kind of impact to mention here today is around automated decision-making and profiling. This is another area where a requirement for regulations that need to be defined regarding automated decision-making and profiling. And there are specific stipulations that need to be defined around access and then opt-out. So what are the mechanisms via which a user can opt out of processing of their personal information for profiling purposes, for automated decision-making purposes? And then also, what is the nature of information and even logic of that profiling and automated decision-making that they will be entitled to upon an access request? Now, I'm going to read this specifically here from the text, exactly what profiling means. And once we go through this, I think it's going to be really clear how this plays in with marketing specifically. So profiling means any form of automated processing of personal information to evaluate certain personal aspects relating to a natural person, and in particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. So a lot of these things specifically around interests and then preferences play into, on the marketing side, personalization on a website. So being able to personalize a user's experience, provide them offers that we think they're going to be interested in order to, just traditional tactics to increase conversion rates and increase consumer experience on our digital properties. Those types of behaviors fall within that definition here of profiling. So it's possible that, again, more to come within the specific requirements that are going to be outlined by the agency, but it's very possible that users will be able to opt out of that processing of their information for those purposes. But also, I would say more importantly, but very important from a business perspective, is at the access point. Within the text, also some of those regulations, including profiling, requiring businesses' response to access requests to include meaningful information about the logic involved in those decision-making, automated decision-making processes, as well as a description of the likely outcome. So it's possible also, even within access requests, that you would need to include context and specifics for the logic that is being used. So if you're developing proprietary models for personalization or for audience creation, it's possible that some of that logic might have to be disclosed. Again, much more to come within the actual requirements as they'll be outlined by the agency, but something to keep an eye out for and something to really make sure that you're adhering to as it relates to users' rights with respect to profiling and automated decision-making. So those are some of the key operational impacts, again, that are introduced by CPRA that go above and beyond those requirements that you should already be meeting strictly for CCPA. Now, I want to discuss here some actions that you can take as an organization. So how can we begin gearing up for these different operational impacts here over the next year and a half before all of these changes go into effect? Number one is start with a data collection audit. In order to understand what information is going to be in scope, we first need to understand what personal information is being collected. So what data is being collected? Where is it being collected? Where is it being stored? How is it being used? Where are the areas where personal information is being used for profiling and automated decision-making? Where are the cases where it is being shared in this new contexts? Where exactly does it flow? We need to audit all of the collection and the data flows and really walk through all of that in order to be able to build that foundation to start defining our strategies, defining our roadmap for being able to be compliant. Now, these audits, luckily, anyone that is already has dealt with, and now I guess about 4 years ago, gearing up for GDPR, you know the process. Same thing with gearing up for CCPA, you should know this process. What I want to impress on organizations is with all of these new regulations, with more regulations being introduced in states across the United States, these types of exercises are no longer going to be, one-offs, huge pains, heavy lifts. We need to create process for these various different audits to make it a normal, recurring, regular thing that is not a heavy lift whenever we need to understand the data being collected, where it's going, how it's flowing, how it's being used. But a big part of that is starting with the audit, understanding that, and then operationalizing it for continued auditing and continued visibility. Number two is documentation and policies around data governance. Controls must be put in place in order to manage those data flows, in order to ensure that the visibility that we're gaining by doing those different audits and the protections that are being put in place are not being circumvented as a result of just a lack of policy and a lack of process in different teams within the organization going off the rails or a little bit there. So number two for actions here to take, make sure that all of your different data practices are well documented. You have policies in place and processes in place to be able to dictate exactly how different teams, marketing, advertising teams are interacting with data. Number three, we talked about data minimization and data retention, and some of the new requirements surrounding those two principles. This becomes extremely important. And the first party data strategy and what I have there for intentful data processing. Again, we can't just collect information and then figure out what to do with it. And my huge fear here is that every publication, I'm sure any partner that you're talking with is now talking to you about what to do and how to gear up for the deprecation of third-party cookies within the web space. As we all know, Google initially was looking to phase out support for third-party cookies within the Chrome browser here by the start of next year. Now, that end date is being pushed back to 2023, but the messaging around that and what really is necessary to gear up for that deprecation is an emphasis on your own first-party data. Getting back to, I guess, my fear here is that as that emphasis grows, and as everyone's talking about first-party data, we can't fall into that trap of collect as much information as we possibly can in order to try to mitigate the risks or kind of change those strategies associated with targeting and profiling and whatnot to account for the deprecation of those third-party cookies, and as a result, the inability to fold in third-party data sets. We have to be strategic. with the first-party data strategy, you have to be intentful with the use cases. What are the outcomes that you're trying to accomplish? What data is absolutely necessary in order to accomplish those outcomes? Is it possible to do so without personal information, without user information? And then if not, specifically what personal information is absolutely necessary, how long does it need to be retained, and making sure that those operational protections are in place to be able to follow that strategy. Number 4 here are explore privacy-focused methods to accomplish common use cases. The first point on here within this is the use of anonymous data. Now, I mentioned it before around users and their ability to opt out. And CPRA expands that the scope of what users are able to opt out of. Now, as a result, it's, in theory, the overall kind of bucket of first-party data that we have to work with can shrink. Now, coupled with that are newer and kind of more all-encompassing methods available to users for opting out. So it was news earlier this year. One of the things that is outlined, but is already operational within CCPA, is that it does allow for a global opt-out mechanism that must be respected. So other ways, for example, if there's an indication within a user's browser that they're wanting to opt out, that would need to be respected under the requirements for CCPA. It's not the only opt-out mechanism is not that a user clicks on do not sell my personal information button on your website. They can also have browser plugins. They can also have indications within the browser. Those opt-out signals would need to be respected as well. It was news earlier this year, the Global Privacy Control, which is a plugin. It's been built into some of the privacy-focused browsers as well. That is a flag, an opt-out flag that the California AG, beginning part of this year, indicated that yes, that type of a mechanism would fall within the scope and the ability that for opt-out. So I say all this to say that while the scope of what users can opt out of is growing, so too is the ease with which users are able to opt out. There's a reduction in the friction that's there for users opting out, which is wonderful. It's how things should be. It should be easy for users to opt out of any kind of processing of their personal information, because at the end of the day, it is their information. From a business standpoint, that means that we need to be thinking about how do we accomplish these various different use cases with fully anonymous data. I talked about it before, or not only with fully anonymous data, but also with just smaller data sets of known identified users and extrapolating insights that we have from those users out across anonymous data sets. So I talked a little bit earlier about things like campaign optimization. Doing that without any kind of user data, perfectly possible. If we're doing the fundamentals correctly, we're appending campaign parameters and things like that to those destination URLs for users entering the website, we don't have to have any kind of an identifier for that particular user in order to be able to understand what sources are bringing users to our website, what campaigns are bringing users to our website, and then also being able to even associate those campaigns with things like conversions, which again, we can observe without collecting any personal information from users that have opted out. We can also then take insights that we have from the users that are not opting out, from those that we have a relationship with, are named users or maybe registered with our websites, and we can extrapolate those insights out across the entire data set. So more ways of using that anonymous data, privacy safe data in order to accomplish those different websites. And then finally here, privacy focused methods around controls and security in the data collection architecture. making sure that there are controls in place in order to be able to indicate users that have opted out, or identify areas where that automated decision making is happening, and making sure that we have data that we can use for general use cases while excluding data from those more kind of sensitive activities. So that is CPRA, overall operational impacts, some strategies and some actions to take, and also just some basics to keep in mind as it relates to marketing and advertising. As always, we're more than happy to help out in any way. Please reach out to us. I'm happy to hop on a call really with anyone, kind of explore your personal situations a little bit more, and provide any kind of point of view and help that we possibly can. So reach out to us either on the Tag Inspector website, on the InfoTrust website. I hope that you do join us in the future for future sessions that we're having here around privacy, around first-party data collection, privacy-safe architecture. And yeah, hope to see you on our future events. Thank you all very, very much for joining us here today, and have a wonderful rest of the week, wonderful weekend.